Hey everybody, it's Mike Kennedy, Vermont Bar Council. I will start with the obvious. What the heck is this video I'm watching? I'm sure that's going through everybody's heads right now. This video is a CLE on legal ethics and professional responsibility, which makes the next obvious question, what the heck kind of CLE is this and where are you doing it from? I'll go in reverse. I'm in my garage. I moved to this place about 1.5 years ago. This is my garage, welcome. I turned it into a garage bar so that when my car is not here, I move it out there and have a TV over there, bar over here behind my whiteboard, which I'll explain the whiteboard in a moment too. That's where we are. Sports theme, got my medals. You get a medal just for showing up for a lot of these races. I didn't win them, trust me. That would be a lack of candor for me to suggest that I earned them. We'll talk about that a little bit later. Anyway, this is it. This is a place. Thanks for joining me. So why are you doing a CLE from there, Mike? Well, I'm doing a CLE from here for one reason. It's March 17th, 2020. So happy St. Patrick's Day. Got my green on and my hat. The bar is not open, by the way. That would be wrong during a CLE. This is coffee because it's freezing cold out here. Besides being St. Patrick's Day, we're right smack dab in the middle of the coronavirus pandemic. So I'm home, like everybody else is, doing their social distancing thing. And while I am, I thought I would. Well, I realize it's going to be a while before we have live CLE again. Who knows when we will be able to get together in groups like that again. Which reminds me, hope you're taking care of yourself, taking care of others, being kind to others, being patient. But again, we're not going to have CLE for a while. Lawyers are still going to need CLE. So I thought, while I'm home, why not film one? Put it up on video and give lawyers a chance to get some credit. So on that topic, I apologize in advance for the lack of tech competence. It's clear by now, I think, that I'm no videographer or filmographer or any of those, whatever the words are. I got a garage with a whiteboard, a webcam that's sitting on top of a propane grill that I'm going to fire up later tonight, make some chicken. Although, just went over and got takeout from my brother who cooked up some really good corned beef today. It was awesome. Thanks, bro. I'm going to post the video, probably uncut. I'm not going to edit it, do any of that stuff. There'll be no graphics, no words. I'm just here to talk and share some thoughts on legal ethics. Today's topic is the 7 C's of legal ethics. It's like an introductory course. It's for all lawyers, regardless of practice area, regardless of whether you're in private practice or government practice, regardless of how long you've been in practice. I'm not going to get into specific practice areas or into specific ethics issues like, say, trust accounting. I'm just going to talk real general. I will try to follow up in the next couple days with some more specific CLEs that are targeted at specific areas or practice areas. Areas of the rules, I mean, or practice areas. But for today, just this introductory course. I'm nervous. Got a script here to try to stick to. I'm kind of shaken, which is weird because I've done, many of you know, tons of these over the last 10, 15 years. But I never lecture. For those of you who have been, you know, I do most of my stuff pub quiz style, which is great for me because I learned early on I didn't like lecturing, and the pub quiz takes it out of my hands. I'm just asking questions and it's all on y'all to answer. Can't do that obviously in this format. When I do presentations that are not the quiz, I much prefer the back and forth, like we're in a room having a conversation. Well, I guess we are in a room in those situations having conversations. But again, that back and forth can't happen here right now. So I'm going to do the best I can just speaking to you. To try to make it a little bit more comfortable for myself, that's why I have the whiteboard out. I hung it today. The whiteboard, for those of you who don't know, makes me comfortable because it reminds me of coaching. Used to be a high school basketball coach, long time, coach middle school basketball right now. And coaches spend a lot of their time with kids, players out where you are, up here, diagramming plays, you know, the X's and O's and the arrows where to go. I feel comfortable doing that. It makes me feel a little less nervous, although I lost my eraser. Here we go. So that's how I'm going to do this, by a whiteboard and by my notes. So first, the 7 C's of legal ethics. Not an original idea from my head. A lot of people refer to the 5 C's of legal ethics. I first heard of the 5 C's of legal ethics about a year ago. There's a great website, Faughnan on Ethics. It's F-A-U-G-H-N-A-N on ethics.com. Brian Faughnan, lawyer who is a fantastic commentator, legal ethics guru in my opinion. Love his stuff. Use it a lot in the course of my day-to-day job. He had a post about a year ago, recipe for successful lawyering or recipe for legal ethics. Can't remember the exact title, but it was about the 5 C's of legal ethics. I've added 2 that I'm going to share with you today. The first 5, though, I took straight from him, and they're a great way to really simplify things. Do you know how many rules of professional conduct there are? In Vermont, and probably in most states, because we all track the ABA model rules, there are 58. I was hoping, and this will be my last prop, I was hoping there were 57. In fact, when I counted last night, studying for this, I thought there were 57, so I had my Heinz ketchup bottle out, so it's 57 varieties. I recounted to make sure, 58. So anyhow, that's a lot to remember when you're trying to just get through the day with your clients and run your law firm. It's hard to simplify those. But the 7 C's, I think, are a great way to do that. So instead of getting caught up in all the rules, which are also complicated, because they were written by lawyers, which means they're not generally in plain English or readable English. They are in legalese. The 7 C's are each one word. And I think if you just focus on the 7 C's instead of getting lost in the S-E-A-C of the rules, you'll go much further towards the most important C, which is compliance. So, here we go. The first C. Anybody who's read my blog? Very first article I did was on tech competence. The first C then is competence. When it comes to competence, you'll see my handwriting isn't competent. Sorry, Mom, if you're watching. Sorry, Sister Norberta, if you're still alive. Anyway, competence, very first rule. I don't know if that means it's considered the most important, but it is the one that they chose to put first. A lawyer shall provide competent representation to a client. Simple, right? Not going to go too complicated on it, because what it comes down to me is lawyers have to know their job and do their job. It's like if you hire someone to work on your house, your car, do your taxes, you expect that person to know their job and to do their job. That is what is expected of you when it comes to your clients. Know your job, do your job. That is competent representation. A couple things I do want to mention with competence. 2 comments that the Supreme Court adopted the last couple of years. The first, I referenced it before, tech competence. The court has made it clear that it's no longer okay to bury your head in the sand when it comes to technology. I don't do tech. Too bad. We're well beyond that. The court has said in the comment to the rule that the duty of competence includes understanding the risks and benefits of technology as applied to your practice and the representation of your clients. A separate comment that's as important, in addition to tech competence, is last year the court acknowledged, after years of the discussion, where we finally realized as a profession that we have a problem when it comes to behavioral health, that well-being is an aspect of competence. To be a competent practitioner, you have to be a healthy practitioner, meaning you got to take care of yourself. A lot of lawyers don't do that. We're starting to get better at it. But those are 2 things about competence that I will add today. Each could be their own separate presentation. I will do probably presentations on each, but just keep those in mind. Tech competence and well-being are parts of the duty of competence. I do think that competence is arguably the most important rule. If you look back in Vermont, it's odd that I say that because I don't know that you would find a single reported decision in the last 20 years, 22, however long I've been here, where we charged, when I was the prosecutor or the current prosecutor, or the one who was in between me and the current prosecutor, a violation of the duty of competence. However, to me, competence encompasses all the rules, infuses every single one of them. For instance, I think competence includes conflict-free representation. Competence includes safeguarding a client's funds. Competence includes candor to the court. It's all those things. So in a way, it could be our only rule, but it isn't. But I think it's one of the most important ones. So that's it on competence. Next, rule 1.4, communication. Now, communication works two ways. Back to confidence, when I turn around and the kids are looking at their sneakers or not paying attention, looking at their phones, they're not going to be competent on the court. So when I'm like this, I want you all paying attention still. It's as important when I'm looking this way as it is when I'm looking this way. That's what I used to say to my players. Anyway, communication, rule 1.4. The essence of the rule is different than what lawyers think it is. A lot of lawyers, at least in my experience, what they've said to me is, well, communication means I get to call my clients back, respond to their emails. That's true, you should. That's a good idea, good business, good ethics. But communication, the duty is set out in the rule is different. The rule says you have to provide, communicate to a client enough information for the client to make informed decisions about the representation and enough information to keep the client reasonably updated as to the status of the client's matter. That's a little bit different than just calling them back, responding to their emails. Some people think that most of the complaints we get are rooted in a lack of communication, but it's not, again, the failure to call someone back, the failure to respond to their email. It's this. To me, it's a failure to communicate to the client reasonable expectations about their matter, about their case. And again, I'll go back to a coaching analogy. When I was the varsity coach, I was really bad at communicating. We kept 12 kids every year, most high school coaches do. Usually only 8 or 9 play. The numbers 10, 11, and 12 get very little, if any, playing time. They're as important to the team as anybody else, the kid who gets the most playing time, because it's a team, it's a unit, it's a group. I was bad, however, at communicating to numbers 10, 11, and 12, look, you're never going to play. I wasn't good at it. I didn't like the confrontation, maybe, I don't know, it's just a weakness I had. Those kids would come to work hard every day in practice, trying to get better, trying to get better, trying to get better, thinking if I just get better, I'll get a chance, I'll get a chance. And some kids do get better, but often, it's just hard because the other kids ahead of them are getting better too. Then they get disappointed when they work so hard by, mid-January, early February, they're still not playing because I never really communicated to them a reasonable expectation that, look, I don't see any playing time for you. It's similar with lawyers and clients. So that was my fault that they were disappointed, not theirs. Similar with lawyers and clients in my experience. I've reviewed probably 4,000 complaints the last 20 years. Lots of times clients will come in expecting this. Lawyer knows that the most client should expect is this, but doesn't tell the client that. Lets client continue throughout the representation to expect this, when lawyer knows client should only expect this. So what happens is lawyer might get this or a little bit more. Client, however, is disappointed that client didn't get this. Why is that? That's because lawyer didn't communicate to client reasonable expectations about the case. I think that's the best way to avoid a disciplinary complaint. Is it perfect? No, but I think you're far less likely to get a complaint filed against you, even when it's bad news you deliver, if you're delivering honest news. Isn't that our job? Candid legal advice. So when it comes to communication, I think the most important thing to do is communicate to clients reasonable expectations about their matter, and then manage those expectations throughout. Next C, we have confidences. Arguably the core duty when it comes to what lawyers do. You know, we want to encourage clients to be candid with their lawyers, confidentiality. They won't be candid if they know that we're not going to keep their confidences. So that's why it's such an important duty. What is confidential by rule? Pretty much everything. The rule says a lawyer shall not disclose information relating to the representation. That's it, period. A comment to the rule says no matter the source. So that makes it broader than the privilege. No matter the source is different than just information coming straight from the client. A couple thoughts on confidences. There are, of course, exceptions where you can disclose information relating to the representation. One is with client consent. Of course, I would argue that competent representation includes making sure that consent to disclosure of otherwise confidential information is informed. The client knows what the client is doing by authorizing you to disclose that. Disclosures that are impliedly authorized to carry out the representation are accepted from the rule. For instance, filing the complaint. Client didn't want anybody to know that complaint was coming, but then you file it in civil court, start the litigation, start the matter. That, of course, is allowed. The other exceptions I really don't deal with as much, haven't seen as much. The first is the mandatory disclosure, which in Vermont, it's not the same everywhere, but in Vermont, for instance, you have a duty to disclose otherwise confidential information related to the representation if the client is going to commit an act that's likely to result in death or substantial bodily harm to somebody. You know, I'm going to the Red Sox game tonight, I'm gonna blow up Fenway Park, thanks. That could fall under that. Haven't seen that, I don't think ever. Then there's the permissive disclosure where you can disclose, you don't have to. That's for things like that fall into that category. For instance, if an ethics complaint gets filed against you, you're allowed to respond. If you're sued for malpractice, you're allowed to respond. If you want legal advice on how to comply with the rules of professional conduct while representing a client, you're allowed to make certain limited disclosures. When it comes to confidences, I'm pretty harsh. You know, I tell lawyers, you know, the less you say, the better, that we talk too much. Reminds me of the old Run DMC song, Homeboy, You Never Shut Up. That's what's going on too often. And the ABA put out an opinion last year that, you know, whether it's at a CLE or a cocktail party, don't start talking about client cases, even if you think you're keeping, you're sort of sanitizing them. Couple areas where I've seen this pose problems for lawyers: when you withdraw from a case, lawyers have a tendency or maybe an urge to put a lot of information in there about why they're withdrawing. I think that's a problem. Could be a violation of the rule. I think it's better just to cite to the provision in the rule on withdrawal, which is Rule 1.16. Then when the court asks for more information in response to your motion, maybe disclose it then in response to the court's question or the court's order. And then obviously these days, the more electronically stored information we have and our clients have, the duty of competence and the duty of confidentiality combine to impose upon a lawyer a duty to take reasonable precautions against the inadvertent disclosure of or the unauthorized access to otherwise confidential information, including electronically stored information. Now, a lot of lawyers think that means that they're gonna, I'm talking about, they store information in the cloud and it's gonna get hacked or somehow compromised. That might happen. That's not necessarily a violation, no different than it was 50 years ago if somebody had something or a client folder in a file cabinet in a locked room inside of a locked building where burglars broke down the wall, took out the doors and made off with the files. I'm talking about when it comes to electronically stored information, be real careful of the simple things. Selling the computer without taking the hard drive off. That happened to a lawyer in Vermont who was sanctioned for that. Replying all to or sending a client an email that you copy to opposing counsel, client then replies all, meaning something to go to you that goes to opposing counsel as well. Think about disabling autocomplete on your email. You know, I've talked about this in the past where someone means to send a confidential ethics inquiry to me, michael.kennedy@vermont.gov. This actually happened where the lawyer sent the information to Michael.K, but it was Kanan, it auto-completed. Michael Kanan at the time he might have still been the state's attorney, he might have transitioned to a judge. Either way, the lawyer was appalled that she made the mistake of sending that information to him when she meant it for me. Very simple example, I'm sure you've all had it happen to you, hopefully not with emails that include client confidences. Then last thing on client confidences, as we move forward towards electronic filing, you know, they just recently rolled it out in the WOW counties, Wyndham, Orange, and Windsor. Make sure you understand how to redact PDFs. You know, I've talked about that at a couple seminars that came up in Manafort's defense, where his lawyers submitted a PDF that they thought had been redacted. Tools very easily were able to give reporters access to the information that the lawyers thought they had redacted. That's part of the duty of competence and keeping confidential client information. In short, when it comes to confidences, I'm always reminded of a lesson my dad taught me that he got through a quote from Thomas Edison, which is, as you go through life, you're going to have plenty of opportunities to keep your mouth shut. Take advantage of them all. Next, after confidences, we have conflicts. So, conflicts of interest. Lawyers can call me with ethics inquiries. I get about 1,200 calls a year. The last time that I checked, which would have been last June, the end of last fiscal year, it was 47%, I think, of the calls I got were on conflicts. They're tough because they're so fact specific. I don't really have any general statements. Just a couple things to think of with the rules. We have different rules for different types of conflicts. There's the conflicts between current clients. There's the former client rule. You know, can you take a case where the new client is adverse to the former client? There's the rule on prospective clients, the client who meets with you but then doesn't hire you. In that situation, the duty of loyalty is relaxed, although you still must keep the prospective client's confidences as if you would with a regular client. So the rules are generally the same, but there are little nuances that distinguish each from each other. Feel free to call me and we'll talk through it. There's also different standards and different analysis depending on whether for lawyers who have a conflict that results from changing jobs. The lawyer who moves from one private law firm to another is going to be held to a different standard in Vermont when it comes to conflicts than the lawyer who moves to and from government practice. We want to encourage lawyers to take government jobs, so that's why the conflict rules are a little bit relaxed there. Similarly, we want to encourage lawyers to do pro bono work, show up at clinics, just pop-up clinics even. The pro bono rules make it clear that the conflict rules are relaxed for those lawyers who are providing those short-term pro bono legal services with no expectation of continued representation. When it comes to conflicts, to the extent there is a general message, what I try to tell lawyers is really two things. Number one, trust your gut. You got where you are, no pun intended, gut. You are where you are because you have a good moral compass, most of us. And a lot of times when lawyers call me to ask if they have a conflict, they feel like they do because something it just feels wrong. And they just need me to hear me agree with them, and that's fine, I'll help you out there. But trust your gut. If it feels wrong, it's probably wrong. And even if it isn't technically a conflict under our rules, the person who you think creates the conflict with your current client is probably going to think it really is a conflict. And they're going to either move to disqualify you, which will cause a delay and cost money to respond to, or they're going to file an ethics complaint, which even if it's not an actual conflict, nobody wants to have a complaint filed against them. It's not fun. So, keep that in mind. Is it worth it to go forward with the case, take the representation where it just feels wrong? Number one, if it feels wrong, as I said, it probably is. And number two, it's probably not worth it going forward anyway. I'm really conservative, I guess, on those conflict issues. But then finally, to the extent you need an image, I tend to think of it as, the duties you owe to your client are supposed to carry you in that direction. If there's anything else that carries you in this direction, that tugs you away, like the old tug of war game, that's probably a conflict. When something is pulling you away from the duties, the direction you're supposed to be going on behalf of your client, that means something, and I think that's a conflict of interest. And finally, remember, in Vermont, we impute almost all conflicts from one lawyer to the entire firm. Exception for personal conflicts. For instance, don't really want to sue that person is my kid's teacher, I feel really uncomfortable, fine, go ahead. That can go to somebody else in your firm. Another exception, the former client conflict for the government attorney, or the attorney who has moved from government practice to private practice, we don't impute those to the other government attorneys or the other attorneys in the former government attorney's firm. But anyway, when you feel that tug pulling you away from where your client wants to go or needs to go or should be going, that's a good sign. Next, candor. It's odd that I even have to talk about candor at CLEs. You would think that telling the truth should go without saying, although my friend JD, his wife Tammy's dad, Tom, he whenever he sees me, he likes to call me a liar. He says it like it sounds like a lawyer, but he says liar. It's pretty funny. But those jokes, there's some truth in them, that we don't have the best reputation when it comes to truth telling, which is odd considering I looked. I think there are 4 different rules that cover candor. The first is the most important. It's Rule 3.3, talks about the duty of candor to a tribunal, which arguably, I said competence is the most important rule. The duty of candor to a tribunal, probably a little bit more important. It trumps even the duties that you owe to the client. So for instance, if you know a client has presented false evidence to a court, or lied to the court, or used your services to commit a fraud upon the court, all sorts of duties kick in. We can talk about them. If it happens to you, call me. Those duties might include disclosing the falsehood to the court. It's really an important rule where the process is more important than your client being able to lie. Don't really need to do a CLE or talk much about that. Something to keep in mind, though, when it comes to the rules on honesty and candor, 2 other rules. Rule 4.1, when you're representing a client, the lawyer shall not make a material misrepresentation of fact or law. Remember, that includes silence by omission, can be a material misrepresentation. Similarly, Rule 7.1 says any communication about your services, whether it's an ad, a website, has to be true. And that, again, there's a similar rule where omissions can be so significant as to be a misrepresentation. And then finally, do remember that there is a rule, it's Rule 8.4c, that says a lawyer shall not engage in conduct that involves dishonesty, deceit, fraud, or misrepresentation. And the court has been very clear. That includes conduct outside the practice of law, outside what you do as an attorney. Not all conduct. What the court has said is it's not every little white lie that's going to implicate the rule, but dishonesty that also adversely reflects on your fitness. So for instance, lying about why you missed a dinner date, probably not going to result in professional discipline, whereas lying on the loan application or lying in an application for an apartment, that will likely result in professional discipline. But the takeaway there is, remember, there are certain things that we do, and honesty is one of them, where what you do outside the practice of law can result in a licensing action. So that gets me through the 5 C's, that the first 5 C's. I've added 2 additional C's. Neither word appears in the rules of professional conduct. Both are very important though. The first has to do with money, and that is commingling. This is it is prohibited by a rule, but the rule doesn't mention the word commingling. The rule says, it's Rule 1.15, and what it says is that a lawyer shall keep the lawyer's property and funds separate from the client's. So basically, when it comes to your trust account, your money shouldn't be in there. Once money is earned, take it out. Now, a lot of lawyers say, well, Mike, how often do I have to take it out? I would say no less than monthly. The separate rule requires timely reconciliation, with reconciliation defined as no less than monthly. But don't let money sit in there. I've seen too many lawyers think I'm not good at trust accounting, I'm not good at bookkeeping, I'm just gonna keep my money there just in case. It's not okay. You know, disciplinary counsel does do random audits. If you look at some of the reported trust account decisions, commingling is treated very seriously by our hearing panels and by the court. So once you get paid, or once you've earned the money, take it out. You can, of course, leave some money in your client trust account that's yours. We changed that rule probably 10, 12 years ago. Remember, I want to get the rule to make sure I get it exactly right. It's in rule 1.15, I think it's paragraph B. Yeah, a lawyer may deposit the lawyer's own funds in a trust account for the sole purpose of paying service charges or fees on that account, and only in an amount necessary for that purpose. So if you don't have a lot of activity on your trust account, or your bank doesn't charge a lot of fees, you can't just dump $1,000 in there to cover what's really gonna be $50 worth of fees per month. That's not okay. You know, that's considered commingling, and what it does is it creates a float, so there's never an overdraft to the account, and by rule, banks have to notify our program whenever a trust account is overdrawn. So that's why that rule, there are some reported decisions where lawyers just dumped a certain amount in there, figuring that was okay, without tying it to the actual fees they incurred. That's not okay, that's commingling. So commingling is something to avoid as a C. And then finally, the last C, civility. Again, a word that does not appear in the rules. Why do I talk about it then? Here's why. A couple years ago, when we started doing the presentations on attorney wellness, attorney well-being, I was at a seminar speaking at Lake Maury for the VBA, talking about the high levels of stress, anxiety, and depression that are affecting the profession. And a lawyer raised her hand and said, you know, Mike, it's not just substance abuse or, you know, outside pressures that are causing the stress and anxiety that we're dealing with. To me, she said, the single greatest source of my anxiety about practicing is other lawyers, how they treat me, how rude they are, how uncivil they are. I don't like it. It makes the job too stressful, too hard. At first, I thought she was going to be an outlier. I started seeing a lot of people going like this, and that has repeated itself at every seminar I've discussed it since. And for Vermont lawyers, it's really important, because at that same seminar, a guy raises his hand, a lawyer, probably around 40, says, Mike, I've practiced in 4 different jurisdictions, and I want to tell you, by far, Vermont is, and I thought he was going to say the best. You know, we always talk about we're such a small community, small legal profession, we know each other, we get along great. He said the worst. Again, I'm looking around and people are starting nodding their heads. So from what I hear, it's bad out there. And we gotta be nicer to each other. Well, nicer is not the right word. You gotta be civil, it's civility. You can do your job. You can be competent and diligent and even aggressive without being a jerk, without being uncivil, without engaging in the name calling. Argue the substance of your case. Don't call the other attorney names. That stuff really has no place. Did talk to a couple of judges who were at one of the seminars I did. They don't like it either. They don't see it as much in open court, where lawyers tend to be on their best behavior, but they did mention that they see it more and more in motion filings, where it's name calling and just ad hominem attacks on the opposing counsel, where one judge said out loud to the gathered crowd, if you think you're doing your client a service by engaging in conduct like that, you're not. So it's not helping your clients, it's not helping the profession at large. My blog post is how I sum it up. The title is Don't Be a Jerk. I'll just leave it at that. So those are the 7 C's of legal ethics. Again, I think if you keep them in mind, it's much easier than getting lost in the nuances and the twists and turns and the colons and semicolons and commas of the rules themselves. I hope it was helpful. I hope you're doing okay. Again, I hope you're all taking care of yourselves and taking care of each other right now. And I'll try to get some more content out there, but anytime that it's all dies down, somebody wants to stop by here this summer and talk with me in the garage bar. You can either talk basketball or legal ethics or whatever you want. Got Alexa back there ready to play some music. Hey, Alexa, play garage playlist. It'll be great. Thanks for joining with me. And I hope to have better video quality for you the next time. Take care.